particular program is going to be on the legal reasoning and also ethics. Ethics is important to legal reasoning because it is basically establishing the values that we have, or oftentimes moral values. And so you find our founding fathers talking a lot about natural rights. And when they talk about natural rights, they're following a tradition of ethics that is known as the Aristotelian tradition, which goes way back to 400 BC, but was also followed by the Romans and was largely followed by the courts. And when they talked about law, they talked about Aristotle's idea. What was Aristotle's idea? Well, he believed in a natural moral order. Some things are just natural, he said. And we don't agree with all of his ideals today, but this was certainly something that the founding fathers were doing. Now, since the Enlightenment, other people got involved, and that would include Kant, Immanuel Kant, who basically had a duty ethics. And the duty ethics of Kant was not based upon the Ten Commandments. Although he was a very religious man, he said his ethics were based upon moral reasoning, that it was based upon reasoning. So it was more similar to, say, what the Romans would have come up with. So if you talk about morality in terms of morality, in terms of values, in terms of his thinking, a couple of things stand out. One is that to him it was very important for people to have respect for individuals. That is, the autonomy of the individual was important for him. So people had a right to maybe privacy, had a right to express their ideals, had a right to pursue their life. And so he was interested in rights as well as duties. So that's the flip side of duties, isn't it? Your duties are oftentimes requiring you to recognize the rights that other people have. And also he had a good interest in respect for humanity. We come to Mills, and although his usually thought of in terms of the greatest good for the greatest numbers, that really is kind of a misstatement. It's very misleading in terms of what Kant actually thinks. I'm sorry, in terms of what Mills actually thought. John Stuart Mills was interested in the individuals also, and he said that it didn't matter if there was a great deal of happiness with the average citizen if you have some individuals who are miserable. We have to consider all the individuals, and therefore a slave state in which maybe a lot of people were happy because terrible work was done by slaves, and so this freed up other individuals to do more pleasant kind of work. The fact that on average there might be a greater happiness amongst those individuals if somehow you took those all up doesn't really make it a better society, that you have to consider every individual as an individual person. So he also was interested in autonomy. So it's not like these value systems were exclusive of one another. So we'll look at each of them in turn. Aristotle's bases for his moral precepts were similar, and he was followed pretty much, and you could find Aristotle, Aquinas, and Thomas Jefferson supporting the theory that there are natural moral rights we are born with. Actually, all the founding fathers talked about these natural moral rights. If you look at conversations between Madison and Jefferson and Washington and Hamilton, these people talked about natural rights and as a moral obligation. Moral rights we are born with besides legal rights of contractual or legislative origin. So you do have legal rights, which are rights that are established by a statute or a law. And so, for instance, there's a law that says that contracts, for certain kinds of contracts, they must be in writing. That's the parole evidence rule, and that's part of a statute. That's a legal right, and it prescribes specifically what it is in order to reach the value, which is probably to maintain some sort of stability so that people can pursue their goals with some sort of predictability in terms of contracts that will be enforceable. And so these moral precepts are artifacts of human invention. John Rawls, also a more recent scholar, formulates two principles. He talks about the liberty principle that holds that citizens are required minimal civil and legal rights to protect themselves. The difference principle, every citizen would want to live in a society where he would be respected and where improving the condition of the poorest becomes the first priority. So basically this was his difference principle. Basically, he would say that you'd want to live in a society where even the worst person, the poorest person, had a condition where his welfare was a priority. Rights and ethics. So we talk about political rights, which are usually established in our Constitution, clearly, but also are thought to be based upon natural rights. So when Lincoln ran for president, he talked about the right of equality. There was no 13th Amendment establishing the words equality of the individual didn't really exist. There was some, we now reckon that in the Fifth Amendment there was some equal protection for, equal protection of the laws, but it was rather limited. The 13th Amendment broadened this concept. And then there are individual rights that basically are attached to individuals. And minority rights. So nowadays we talk about minority rights. Property and contractual rights are things that individuals establish between themselves. So you buy property from somebody, that's a transaction, oftentimes evidenced by a contract. And the contract establishes certain rights. So these are also there. So minority rights have been established by contract, by legislation, civil rights legislation, which are very important to us nowadays. Political rights. In Western civilization, these were a restraint on the ruling power. Political acts and speech were protected, so the right to vote is important, and speech. Although how that who got to vote was certainly very limited by the Constitution. The original thinking of the founding fathers was that only individuals who maybe had property should be able to vote. So it was very limited to white males who had property. This was gradually expanded so that by the time of the Civil War it included all white males, but didn't include women or slaves, although they were counted for terms of, and therefore basically increased the representation of the states. The number of slaves you had would increase the number of representatives you had. Not the same as if they were counted as individuals, but they were like 2/3 for the slaves. Women were fully counted, but they didn't vote, nor did the slaves. Political acts and speech are protected. So free speech. Free speech is something which was largely restricted by the founding fathers. If you know the history of that, there were acts that were passed that restricted speech. So Jefferson complained about acts that Adams passed, and the Federalists who voted out office when Jefferson came in complained about Jefferson's restrictions on speech to them. We really find our free speech being greatly expanded at the latter part of the 19th century and into the early 20th century. It really began to be established to where we now understand it to be more full than what we did at that time. So these things had gradually changed our conception of them. The people supported these changes, and I think that's why you find the Supreme Court finding it that way. You find that a lot of the things that were done when Roosevelt was in office and prior to Roosevelt taking office, he changed things, and so he enacted things and expanded the rights of people. And the Supreme Court had at first voted out a lot of his legislation, which was very expansive. That changed after the election of 1936, when Roosevelt swept the polls and had such a majority that the Supreme Court was actually probably concerned about its own legitimacy as representing the people. They said, well, we're not basically a democratic institution. The Supreme Court is supposed to be a balance to protect the rights. but we need to actually represent, we need to be aware of what the people want, and therefore they began to vote on the side of Roosevelt's expansion of the New Deal. And you know, largely many people think that this was because of the election of 1936, which had great support for Roosevelt and the Democrats who he supported. So that was a big expansion. Private property. Private property, like we said, is something that exists rather independently, and it's a right. It's an important right, just like that. However, prior to the New Deal, in the early days of the Republic, private property seemed to be the primary right. Other rights seemed to be diminished or were not treated as being taken as seriously. Now it's somewhat the reverse. Private property is not necessarily seen as important a right as, say, freedom of speech or the right to vote. So there's been a change in how people think about these rights. Divine rights. Historically, the West believed that God had made the laws and that the king was his divine representative on earth. Obviously, we as a nation rejected that view. So there was this concept of divine rights. The king, under that, King George could do no wrong, and so that would be represented by the idea of sovereign immunity. And we still have, to some degree, sovereign immunity, but the Congress and the legislatures of the states have largely voted away a lot of the sovereign immunities to where it's not what it used to be. It's still there, but it's not quite as expansive as it once was. Also, the king was seen as a father of the people. Okay. Natural rights. This is in opposition to royal overreaching. Historically claimed that the divine law invested rights in others, and these were referred to as natural rights. So this was a counterbalance to the divine rights of kings, that there were certain things that the people had. When Western societies became democracies, they retained these rights of the people, such as to pursue your own happiness. Life, liberty, and property is what the Constitution talks about. So you see in that, again, property is an important right for the Founding Fathers. Okay, and so there's some restraint upon the when the Western societies became these rights. You know, and also it was seen that democracy was a restraint upon the government's power, not just the king's power, but any government. So, you know, when in the early days of our republic, there was lots of criticism of political leaders sometimes in terms of Adam was accused of being a royalist, that is, of wanting to impose a government. Even Washington was accused of that, which obviously he was not. But you had this kind of thing. Right to self-determination. So this is consistent, say, with Kant's ideal of autonomy. But it's also consistent with utilitarianism. Inherent to the ideal of democracy is the right to self-determination. So part of that is the right to vote. One of the problems, you can see what happens to a society where you deny a group of people the right to vote. If you look at the post-Civil War era in which the southern states denied the vote through the black codes, through laws that they passed, and denied the vote to the black citizens of those states. And so the reason they were able to have those laws was because they were denying the votes to those citizens. And so in 1965, when we finally passed a Civil Rights Act and enforced it, there was a Civil Rights Act passed after the Civil War, but the Supreme Court gutted it and basically didn't follow it. So these interpretation of these things are what really sometimes what turns on. So in interpreting our laws, the Supreme Court plays a major role, and it needs to be. There needs to be somebody who interprets this and says what it is that it actually means, because oftentimes legislation is not written clearly, and it oftentimes should be read in sometimes a very expensive way, especially in terms of rights that people have. Anyway, so right to vote includes the right to form parties and support candidates and to give and receive information. A right to participate in government, to petition, to protest, to run for office, to serve as a juror. These are all things that were denied to blacks in the South under the Jim Crow laws of that era. And, so consequently, blacks were kept in a very impoverished condition without much opportunities. And so individual rights. Individual rights are marked by the need for people to have autonomy and to have respect. Rights to be left alone by others. So, you ought to be able to read whatever you want to read, and you ought to be able to express your mind independently. And in society, a democracy works better if people can actually express themselves. It's much better to know what people think. Even if you don't agree with the person, it's much better to know what he actually thinks rather than him lying or trying to distort what he says. Now that happens anyway, because if your views are unpopular, you might want to basically distort your views and lie to the public, basically. But on the other hand, if your views are popular, you'll probably want to, expand them. And actually, you might want to try to co-opt views that are popular and pretend that these are your views when it's not actually that. So we've seen politicians do that. Okay, so opportunities to participate in the competition for future benefits is what we're talking about. So, the right to vote and the corollary rights would be along those lines. Autonomy and respect. Freedom of belief in the true nature of God or and true nature of things, God or no God. Men are greedy. Basically, people have different opinions on these kinds of things. And therefore, what people will, think would be a good law, or what they think should be enforced, or or whether or not they think a politician is doing the right thing, will depend upon what they think. Well, every individual has a right to what they think, and we ought to be able to debate these things in public and respect people's views, even where we do not agree with them. And unfortunately, we've had a history, you can see it in the early republic and you can see it in the present day, of sometimes people's views being distorted and people basically distorting their views and trying to pretend something that they're not, and trying to suppress other people's views. Freedom to pursue a non-criminal lifestyle, certainly. Freedom of expression within limits. We have these things. Freedom to move, travel, and relocate. In the 20th century, we've had a better approach to that than what they had and prior to that, in the 19th and the 18th century. We didn't. Oftentimes these rights were more constricted by even the founding fathers. And you begin to see it open up under Lincoln. Lincoln was the first one to push for that and did a great deal of politicking to get rights for black citizens, but actually for other citizens as well. And he was very concerned with the rights of soldiers. And so if you were not happy with the way your son was being treated by the Army, you could write to Lincoln and maybe he'd give him a pardon. So he tended to do that. And he also approved the practice of certain generals who decided to emancipate slaves that had come to them. And the argument that these generals developed was that they were contraband. And even though Lincoln had said he wasn't going to free the slaves when he campaigned, he did say that he would free the slave if it was necessary to free the war. He said, he would free no slaves if he could keep the Union without it. He said he would free all the slaves if it was necessary to free the war. That's what he wound up doing, because the South persisted in wanting to use its slaves as labor for supporting the war. And so this is the argument that these generals like General Butler argued, that he was the first one, that these were contraband, that these were property that were being used by the South to further the war effort, therefore could be confiscated as contraband under the rules of war. And Lincoln said, okay, that sounds good, we'll do that, because he realized the advantage of that, and it would be disadvantageous for us to have to allow these blacks to be sort of pushed into laboring and even fighting perhaps for the South when they really weren't really wanting to do that anyway. and they'd come over into the lines wanting to be emancipated, and these generals were emancipating them and putting them to work. And they did. They worked, and they would build fortifications for the Union. So they were a great benefit to our forces. And it was also great for public morale and public opinion, because the public said yes, they were glad to hear that the black slaves were fighting for the Union. But it was not only black slaves, but it was free blacks also who were fighting for the Union. But some of them were slaves who had escaped from their masters and had been emancipated by the generals. And of course, the South claimed that this was unconstitutional because they were property. And yet the general was saying, yeah, they're property, so okay, we're going to call them contraband, we're going to do that. So it was kind of like the reasoning is kind of strange, but it gets to certain values, I think, that are important. So that's why I'm putting an emphasis more on the values that we have, and not so much on syntax and how we define things. Do we define persons as property? That was actually done by Chief Justice of the Supreme Court, and that's one of the worst decisions, in the Dred Scott decision, that we defined them as property. And of course, we recognize that as being wrong now, but at the time that was the argument, that they were property, and we don't recognize that now. Our values have certainly changed that way. Ability to make the best use of the opportunities that people have is the basis of distributing opportunities. So people ought to be able to pursue whatever talents they have to their best effect. Free market transactions, so people ought to be able to engage in economic activities in order to better themselves, establish a business if they want, to work as laborers, or work as managers, or work as owners, or to work as freelancers. However they want to work, they ought to be able to work like that, and they ought to be able to pursue whatever kinds of fields, whatever kind of work they like. Patronage or relationship or reciprocity is an important thing. So actually relationships, whether it's reciprocity, where you scratch my back, I'll scratch yours, or whether it's you have somebody who's going to actually sponsor you, and so you can engage in something and you will benefit him by doing that, which you see in a lot of partnerships where one partner owns basically this and the other partner runs it, and they both benefits. The person who put the investment in, who put the capital in, he gets a return on his capital, and the person who puts in the effort, he also gets a return for his efforts. So that's patronage, isn't it? So power is also something that you should have, and so we have power in the economic sphere as consumers. We determine what is being bought or sold as individuals, and therefore we create jobs, right? Because demands are created by jobs. It doesn't do any good to have a restaurant unless people want to go there. So you see this in COVID-19, that one of the problems isn't that the government has restricted people going to restaurants. A lot of people are not going to restaurants even where the government has declared it open and said that people could go. And so restaurants are still suffering from not having the kind of patronage that they had prior to that, because as individuals they've decided that they don't want to risk the going to restaurants as much as they used to, so they're reluctant. And so also restaurants have to provide them with more space. And I suppose, and you would probably see that states where they're not enforcing these kinds of laws will gradually, the people themselves will actually begin to realize that they shouldn't be congregating too much. And this will reduce it without the government doing anything at all. But that has actually got a negative economic impact. But we're concerned, and we should be concerned, with people's right to be free from danger and not to take these risks. A very controversial value that came up now in the pursuit of equality. We have actually instituted a lot of affirmative action. Basically, when we did that, the court was very specific that it required proof of a specific past discrimination that has created an actual existing inequality in that particular workplace or in that particular area of law of interaction. say in buying a house, banks used to redline certain property and would not loan, and actually realtors would not maybe sell certain properties to blacks, and so you would have these very white suburbs, which we no longer have because we have recognized this after the passage of the Civil Rights Act. We recognize that people ought to be able to buy houses in whatever neighborhoods they want to live in, and that's a matter of civil rights, which of course was very much opposed by some people who said it was unconstitutional. But it's not unconstitutional because it's part of the equality that was meant to be given to blacks specifically under the 13th Amendment. And so that's the justification for it. So that value of equality, wanting to create an equal society, supports this affirmative action in the buying of houses in whatever community we want, getting a loan so you can buy those houses on, you know, a fair basis. Just, you know, if you have the income and you have the credit, good credit record, you ought to be able to buy a house, which was being denied to blacks. Also, voting was very much restricted in the South, and so they enacted the Civil Rights Act in 1965. A large part of that was to do away with the bogus Jim Crow laws that prevented blacks from voting. Things like, you know, requiring them to read when the only person who ever actually proved that they could read were blacks, and the test was administered in a very discriminatory way, and people who could show that their grandfather had voted before the Civil War, before 1865, would be automatically not required to meet these restrictions. Poll taxes, these were all done away with. And unfortunately, we find that today the Supreme Court is retreating on these rights. In the Shelby County case, they basically allowed restrictions on the voting, and you find states, especially southern states, but even some northern states, acting in ways that are designed to restrict voting very much more than there used to be. Gerrymandering and other means are being used to do that. And so, and affirmative action itself has also been diminished in terms of the job. Many people feel that we've had it for long enough and that we no longer need it. And so you have actually state legislatures passing laws, you know, basically prohibiting affirmative action in, say, universities like Michigan University and other universities and other state facilities where, you know, they're prohibiting affirmative action in these programs. And these are being upheld by the Supreme Court. And of course, these are 5-4 decisions, so it's rather interesting. So we'll talk about those as we get into the regulation. Does not contemplate, affirmative action does not contemplate taking away any currently vested rights of the majority. So, you know, when we passed the Civil Rights Act of 1965, when we passed the Equal Employment Opportunity Act of 1964, you know, companies were not required to fire anybody, and a person who had a job was guaranteed a job. All that was done was that employers who had discriminated in the past would have to institute an affirmative action program and consider race as one factor in that. They could still continue to hire white individuals, but they had to make an effort where they had qualified individuals to actually employ those people. They were not required to hire unqualified individuals. It's just all kind of a fake news that that was required, and it wasn't. Which met and will end the, so anyway, they required the establishment of goals and timetables in the employment, which when met will end the need for affirmative action. Does not contemplate taking away any currently vested right of the majority. Retribution, demands for payment of past wrongs. How does a minority member show he is entitled to just sum? Who is to pay, and that is who owes him the sum. Payment is to be made to a group. What form will it take? So if there is in fact claims for retribution, they have to be established, and I don't think we've ever made any kind of outrageous distribution like that. Anyway, property and contract rights. These are our government and the other progressive governments of the world have entered into conventions through the UN to promote international rights, which is something new. So we have a convention against torture and other cruel things. So there's that. There's also other rights that are protected. So that was in 1974, I think. Convention Against Torture and Other Cruel and Inhuman, Degrading Treatment or Punishment, ratified by Britain in 1988, the United States in 1994. So these things have to be ratified. We recognized that convention in 1994. There had been previously some protection for soldiers in war, but this was more broad. This related to any citizens. So actually, this is, some people say, well, our country is being controlled by other countries. Well, no, we recognize these rights, and where somebody has made a case, we recognize that right, and it still has to go through our courts for recognition. So 169 countries have ratified this Convention on Torture and Other Cruel, Unusual Punishment. Of course, there is no world governing body with the power to enforce these even ratified treaties. So that's kind of a myth that people think that there's some sort of world government that enforces it. If we enforce it, it's because our courts decided that these are important rights, and that any citizen who comes here ought to have, not any person who comes here ought to have certain rights. And so this, of course, relates to the immigrants who come up from, say, Mexico or from other countries where they're being persecuted. And so we look at one important case which has come up is the Pinochet case. After acquiring incredible wealth, Pinochet, who was ruling Peru, he retired and in 1998 sought medical care in a British clinic. Scotland Yard arrested him with intention to extradite him under a treaty to a Spanish court for trial. So the Spanish court filed papers for extradition of Pinochet for his treatment of his citizens in Peru. And so they had evidence, testimony, and other evidence to try him, and they wanted to try him and give him a fair trial. Of course, he didn't want to stand for trial at all. And the British government wound up turning him over to them. So I will go through to it. There was top people, including the Prime Minister of the country, who opposed the extradition. But eventually the High Court of Britain decided that they were going to actually allow his extradition. Okay, so after World War II, our nation, our country, and the European powers who had run, the Allies who had run, wanted to make sure that nothing similar to what had happened during World War II would arise again, where a horrible dictator basically imposed his will and and led his nation into a terrible war, and so we began to be concerned with enforcing rights within countries and preventing people like Pinochet from ignoring the will of the people and suppressing their political rights was very important to us. So after World War II, and the diplomats representing the winning Western democracy sought ways to avert future conflict, and they created the UN to do this. And the UN established in 1948 the Universal Declaration of Human Rights. And so that was, pretty much unanimously passed by those nations. Some argue it is binding international law, but of course it is not any nation. It requires every nation to recognize it, to affirm it, and so nations continue to have their own sovereignty. However, it provides a mechanism to put a little force on them and provides a justification for a country like Britain or the United States to deny protection to people who have come here who have a history of suppressing their own citizens. So the Declaration does not, of its own force, impose obligations as a matter of international law. So this is a 2004 decision of the Supreme Court, Souza versus Alvarez. So, you know, like I said, there's not like a world order that's imposing it on us, but it's something that we had chosen to support and continue to some degree to support. So this is by our own thing, and it has to go through our own political process, including it has to be approved by our courts, meaning the Supreme Court as the final say. The International Court of Justice statute defines customary international law as a general practice accepted as law. This is generally determined through two factors: the general practice of states, which states have accepted as law. So a lot of this was formed upon what our rights are, but some of it goes beyond what our rights are. Even though it is not legally binding, the Declaration has been adopted in or has influenced most national constitutions since 1948. It also serves as a foundation for a growing number of national laws, international laws, and treaties, as well as creation of a number of NGOs which seek to promote these rights. Why are we talking about rights in a business law course? Well, because our commerce, our trade is increasingly international, and actually what led probably to the first Great Depression was the shutdown, and because of the blockades of goods, where we would not we would impose tariffs. The tariff laws of the United States and other countries probably were what led to the first Great Depression, and maybe to some extent what we're receiving now is not just simply the pandemic, but also the effect of these trade wars. Trade wars are not good, and the nation's prosperity shot up after World War II. In some degree, that was because of international trade. So we actually were rebuilding Europe, and Europeans were paying for that large part. We did send some aid to them, but they wound up paying for that aid. And so there was a big transfer of wealth, largely from Great Britain to this country. Great Britain had borne the cost of the war, both during the war and after the war, largely. And so that's when we became the #1 economic power. Before World War II, Britain was the great power in the world, the great economic power. We became the great economic power after World War II, largely because of this international trade. So we viewed it as something desirable then. In recent days, people are worried that we are losing jobs on account of it. I don't think we lost jobs on account of international trade. I think we lost jobs because of the expanded use of robots and artificial intelligence. And so that's entirely, even though it is not legally binding, the Declaration has been adopted or has influenced most national constitutions, as I said, as well as the creation of a lot of non-governmental organizations which seek to promote these rights. So again, these are just pressure groups. They're not binding laws. You don't have to do what a national non-governmental organization says. They don't have any power. They're just pressure groups. So on the PowerPoint slide, I have the Universal Declaration of Rights, and if you look at that, you'll be surprised at how a lot of it is reflecting our own values in our own Constitution. But some of it goes beyond that in some ways. And so I've got all these there. I'm not going to talk about them now. So yeah, you can look at these on your own. And then I got some non-governmental organizations listed. And so that'll be it for now. There will be a test, a quiz, that you'll need to respond to. Okay, thank you very much. Thank you.